A very good morning to all my dear students. Today we are going to learn the concept of and the issuing of commissions by the court of law in a civil suit. As you all are aware that the concept of commission falls under the category of interim orders. Furthermore, it has resemblance to that of interim orders. As such, in view of these submissions made herein, I just want to recapitulate certain important points which is of immense importance for the understanding of the concept of or the issuing of the commissions under Order 26 by the Court of Civil under the Code of Civil Procedure. Hence, before starting with today's topic, the same needs to be understood. So in this background, we are going to start the relationship between interim orders and the commissions given under the Code of Civil Procedure. Now let's start with the same, my dear students. As far as the word interim order is concerned, the same has not been defined in the Code of Civil Procedure. My dear students, as you are aware that the Section 2 of Code of Civil Procedure defines various expressions or concepts which are of immense importance or used to be applicable thereafter in the code, has been defined in the code itself under Section 2 thereof, wherein various definitions such as judgment, decree, order, foreign code, foreign judgment has been given. But the legislature has left out to define the concept of interim order therein. As you are all aware that the word interim has not been defined, but the law lexicon defines the said word interim as for the time being, or temporary, or provisional, or not final, or intervening. So these are different words which may be used for the understanding of the concept of interim as used under the Code of Civil Procedure. Furthermore, we can also define interim order as orders which are passed by a court during the pendency of a suit or proceedings which do not finally determines the substantive rights and liabilities of the parties in respect of the subject matter of the suit or proceeding. So from this, my dear students, we may infer that the order which finally decides the substantive rights would fall under the category of order as defined under Section 2, Clause 14 of Code of Civil Procedure. Furthermore, or as distinguished from interim order. Interim orders means those orders which are necessary for the determination or for the preservation of a property under the dispute till the pendency of that particular suit. It would not be in force after the final order has been pronounced, and meaning thereby the interim order may be submerged afterwards into a final order. If the final order relying upon the interim order. Next, what is the object behind passing an interim order? The object behind passing of the interim order by the court of law in a civil suit or during the pendency of the civil suit by a court of law, it is to assist the parties to the civil suit in the prosecution of their case before the court of law. So this is the object, or for the purpose of protection of the subject matter of the suit and thereby to administer justice. My dear students, as you all are aware that it is the duty of the court to administer justice. As such, to administer justice, it is also been empowered to the court to protect the subject matter of the suit. Furthermore, it is also to protect the rights of the parties during the interval or in the interval between the commencement of the proceedings and the final determination. So from this, we may infer that interim orders are also to protect the rights of the parties in the interval between the commencement of the proceedings and final determination thereof in a civil suit. And these orders would be passed as the court may deem fit and thereby to do justice, or as the case may be, equity demands. So from this, we may infer that these types of order are of equitable nature, apart from statutory nature, and thereby to prevent any abuse of process of court of law during the pendency of the proceedings. So, my dear students, from this, we may conclude that interim order plays a crucial role in the conduct of litigation between the parties to the civil suit. Next, what are the relevant provisions for issuing the commissions? The relevant provisions for issuing the commissions are given under Order 26, that with Section 75 to 78 of Code of Civil Procedure. The power to issue the commissions is discretionary, meaning thereby that this power has to be used by the court of law in a very judicious manner and not capriciously or frivolously or malafide, meaning thereby the court's duty is to administer justice, and as such, the power given under the provisions of Order 26 has to be applied in a very judicious manner, meaning thereby to apply its mind by the judge, and thereby to give full and complete justice between the parties. Now, the next question, which is very important from the point of view of the learning of the concept of commissions, is that under whose application the commissions can be issued by the court of law. The law pertaining to it has been laid down, as it can be made either on the application by the party to the civil suit or of its own motion, meaning thereby the court has also the power of suo motu to apply its jurisdiction qua issuing commissions in a civil suit. Next, what are the purposes for issuing the commissions? There are 6 purposes which have been given under the Code of Law, Code of Civil Procedure. That is under Order 26. The first purpose is to examine the witness in a civil suit and also to make local investigation with regard to the subject matter prescribed or given under the civil suit filed by the plaintiff against the defendant. Next, to make partition qua the immovable property, which is the subject matter pending before the court of law. Next, to hold investigation and also to conduct sale of movable property. So from this, we may infer that the commissions can be used not only for the immovable property, but also for the movable property as well. And also to perform ministerial act under the Code of Civil Procedure. So these are, my dear students, so these are 6 purposes for which the commissions can be issued. Next. The first is to examine the witness. Now I am going to explain the same herein a little bit further. The relevant provisions for the same are given under Section 75 to 78 and Rule 1 to 8 of Order 26. The general rule with regard to issuing of the commission for the purpose of examining the witness is that all the persons, whether it's a party or the witnesses to the party or witnesses to the case, all need to be examined in open court. What do you mean by open court? Open court means in which all the public is having the access to justice, and it would be differentiated from the word closed court, where only the parties to the case and the judge and its staff are there, and no public, no outside public be able to enter into such kind of proceedings. Closed proceedings are also found in the case of family matters and also in the cases of pertaining to the rape matters as well. Whereas in other matters, the courts under the law are deemed to be an open court. Next. So from this, we have to look at this concept, because this is an exception to the open court concept, meaning thereby Order 26 is an exception to the open court, where one of the party, by way of his sickness or infirmity, or if there is any detriment to the public interest found by the court of law and agrees with the application of the party, then in that circumstance, the court may exempt him to appear before the court of law and issue a commission, and thereby to apprise the parties to appear before the said commissions. Example, if a party or a witness apprehends danger to his life, if he appears before the court, then he can be examined on commissions. Next purpose is to make local investigation. The relevant provisions for this are Rule 9 and 10 of Order 26. The purpose of local investigation is to elucidate any matter in dispute, meaning thereby to ascertain the market value of any property or the amount of any Nestle profits or damages or annual net profits. Next. The next purpose is to adjust accounts. The relevant rules pertaining to same are given under Rule 11 and 12. of Order 26. In this, the court may direct the commissioner to adjust the account and thereby to submit the report before it, and that report of the commissioner would be treated as evidence in the civil suit. Next purpose for which the commission can be issued is to make partition. The relevant rules pertaining to the same are given under Rule 13 and 14, meaning thereby, as you all are aware, that after the passing of the preliminary decree in a suit for partition, the court may appoint the commission for inquiry and divide the property. As such, this power is delegated to the commissioner, and once he has done with his work, he has to prepare a report and thereafter submit the same before the court of law, and court shall, after hearing the objections of different parties, make the final allotment. Thereby, meaning thereby, a final decree would be passed in the case of may be passed in favor of the parties to the case. Next, to hold investigation. Questions involve any scientific investigation which cannot, in the opinion of the court, be conveniently conducted before the court, then court may, my dear student, in the interest of justice, issue a commission to such person, thereby to direct him into such question, or also to submit the report thereon to the court of law. Next purpose is to sell the property, and this selling of the property is mainly of movable property, and this was added by way of amendment in the year 1976. In this also, if the court wants to sell the movable property, which is one of the subject matter pending before the court of law, then in that circumstance, the court may appoint the commission, and after recording reasons and in the interest of justice, direct the commissioner to conduct the sale and submit his report thereon. The last purpose for which the commission can be appointed under the Code of Civil Procedure, that is under Order 26, that is to perform Ministerial Act. The relevant provisions is given under Rule 10B. This was also added by 1976 amendment, whereby the court may appoint the commissioner to perform any ministerial act and thereby to record its reason, and in the interest of justice, the court may direct him to perform such ministerial act and submit the report of the same before the court of law. Next, what are the powers of the commissioner appointed by the court? The first power which has been given to the commissioner is to summon and produce the attendance of the parties, their witnesses, and examine them. Thereafter, call for examining the documents as well. Third, entry into any land or building mentioned in the order. Further, proceed ex parte if the parties do not appear before him in spite of the order of the court. So these are the powers of the commissioners given under the law. So this is all about the concept of commissions as provided under the Code of Civil Procedure, that is under section 75 to 78 of the CPC. Hope you have learnt a lot from today's lecture. In case of any query, then you may write it to me, your queries, at my email ID, that is rahularora.gn@jagannath.org. But before parting with the today's lecture, I just want to apprise you about my new topic, which I am going to take in my next lecture. And my next lecture would be on temporary injunctions. The relevant provisions for the same have been given under Order 39 CPC. Thank you very much. We'll meet you soon. Till then, stay home, stay safe, and be positive. Have a hope you have a great day ahead. Thank you very much again.